So be sharing my screen. So set that up now. All right, perfect. All right, we might get a start. So welcome everyone to our first tutorial for Criminal Law 1. So very exciting. I know you guys have just started the content this week because it starts later than your other law subject. So yeah, I guess we'll just do a bit of introduction, a bit of housekeeping, and then we'll jump into the content. And yeah, if anyone has any questions throughout the tutorial, they can put their mic on and ask or put it in the chat or wait till the end. And I'll talk about emails as well. You guys can send me questions via email as well if it's like more specific question about the content. All right, so firstly, I wish to acknowledge the people of the Kulin Nations on whose land I join online from today, and I pay my respects to elders past, present, and emerging. So just quickly, I will introduce myself. So my name's Vanessa, and I am a second year law student. So I was previously doing law and international relations, but I've just switched into straight law now, which was an interesting decision. So yeah, now I'm only doing law subjects, which is a lot, but I'm enjoying it. And yeah, I completed criminal law last year, so it's been my favorite subject so far. I found it really interesting. Definitely liked it a lot more than Foundations of Law, which you guys have been doing for a couple of weeks now. I spoke to a couple of first years and they said that there's lots of reading. So yeah, I understand that Foundations of Law, yeah, is a lot of work for your first law subject. So yeah, hopefully you guys enjoy Crim a little bit more. I know I did. And yeah, I guess I ended up getting the highest score in the cohort for Crim. So hopefully you guys are in good hands with me and I can share some tips and kind of what I did to achieve a high distinction. And yeah, I want to go into probably commercial law. I don't really know yet, but criminal law is interesting, so we'll see. Still got a while to finish my law degree. All right, so just quickly, as I said, we'll be covering a couple of housekeeping things very, very quickly, but I just want to talk a little bit about academic integrity. I'm sure you guys have heard about this before with Monash. I think you had to complete some modules at the start of the year. But basically, the Monash LSS, so the Law Student Society, strictly condemns academic misconduct and has zero tolerance for policy for persons who are found to have breached their academic integrity by misusing educational services. So this tutorials program is just a supplementary resource. So we aim to provide you guys with extra assistance and going through the content and problem questions. But the main thing you guys should turn to for criminal law is obviously your faculty and your lecturers. So they are your first point of contact. And yeah, your workshops and tutorials and seminars, and these sort of tutorials cannot only be relied on for learning. Whilst they're really good, and especially for revision and for consolidation, they cannot be, yeah, your primary source for learning criminal law because we can't learn it in just 1 hour a week. Hopefully, you guys will get a lot out of these. And I think if you've already done the content throughout your classes and come here to consolidate that and do extra practice questions, that is the best way to then get those high marks. And yeah, while our tutors, so me, we work really hard to deliver value and unit content, the reading guides can change. So I completed the subject last year and I have spoken to the chief examiner. So I do know what your reading guide is and what you guys will be covering this year. It hasn't changed much from what I did last year, but there might be a couple of discrepancies as there is every year. Obviously, the law is always changing. So it is just really important. If there's some inconsistency or something that I say that maybe your workshop tutor says differently, to just listen to them because they're the ones that are going to be marking you guys at the end of the day. And yeah, if you guys have as well any questions about inconsistency, maybe you can be like, oh, my tutor said this last week. I can also go speak to the chief examiner and see where that inconsistency comes from. But yes, always listen to them first. All right. So, and just lastly, last bit of housekeeping, I'd like to take the opportunity to thank our sponsors. So these are some law firms that kindly sponsor the LSS and help us, keep on running, which is Cause Chambers, Westgarth, Clayton Utes, King and Wood Mallisons, and Gilbert and Tobin. All right. So, just quickly, I know you guys have started criminal law this week, so you might have not looked ahead. You've just kind of done the first week of content. But I just wanted to quickly go through the structure and what we will be covering throughout the semester. So, what's really good about criminal law is that it's just a nice and kind of really structured and sequential unit. Um, and yeah, it doesn't really jump around. I think I found with a lot of my other units, like some things jump around and then you go back. And so this one is very, very nice and easy to follow. So topic one, which is what we'll be covering today and what you guys have done in class this past week, is introduction to criminal law. So talking about crimes, punishments, all of that. And then, yeah, we'll move on to sentencing next week. Elements of a crime. This is really, really important one because the elements of a crime will then be applicable to all of the other crimes we'll be learning about. Um, then we're going to learn about non-fatal offences against the person. So these are offences such as assault or threats, and then sexual offences, homicide. Firstly, we'll deal with murder, and then topic 7 will be manslaughter and then defenses. So yeah, you can kind of see how it's nicely outlined, and we learn about the elements first and then apply them to each different crime. So obviously criminal law is very interesting because yeah, we learn about I think yeah, very, very interesting parts of the law, but obviously some of these things can be a bit confronting as well, and some of the cases we'll learn. I find them very interesting, but yeah, just keep that in mind as well. It's not like foundations of law where, the cases are maybe old English cases about just some random stuff that's happened. This is, yeah, can be a little bit confronting for some people, but I will put disclaimers as well when we cover those. So as I said, I did speak to the chief examiner, and these are your assignments for this semester. If any of these are wrong, by the way, let me know if anything's changed because he did say they were locked in, but he said there might be some minor changes. But I mean, this is also what we had. So we had, yeah, 2 multiple choice quizzes which cover the topics 1, 2, and 3, and then your mid-semester assessment. So that's on topic 4, and that's been finalized. So it comes out on the 28th of April. So in exactly a month's time, it's the 28th of March now. And then you guys will have, yeah, like 2 weeks to complete it. So yeah, we don't have to worry about that for another month, which is good. But just something to keep in mind. And then the exam. So I don't know if you guys know, but this year will be your first in-person law exam because Foundations of Law, you have an exam, but you get to take it home and complete it. I think if it's the same as last year over the course of like 3 or 4 days. So yeah, this is first in-person exam, which can be scary, but yeah, it is. It's not too bad.
Hey
Right.
Vanessa, sorry. So I
Yeah.
didn't interrupt you. Your slides are just stuck on slide 1.
Oh, are they?
So I
Okay.
think when you press slideshow, it must have like taken it out and it's just keeping the other
Mm.
screen. So
Okay. How do
the
I pause this? Okay, let me just stop sharing. Oh, maybe this one? Yeah, let's see. Sorry, guys. Can you see that now?
yeah, perfect.
Okay, sorry. Let's just, oh, okay, I'm just gonna go back. Sorry, that is really annoying that it's just been on this one. So yeah, I'll just go back through. Let's just introduce myself. This was the stuff about academic integrity, sponsors, and then yeah, this was the outline. If you guys want to even take a screenshot of something of my screen so that you can have that, what we'll be going through. As I said, we'll start with topic 1 today. Yeah, I recommend taking a screenshot because it's nice to kind of just know, yeah, each week what we're going through and kind of follow along with that. So I'll leave that up for a second. Um, yeah, so basically, we only really cover 4 sort of main offences, which are, as I said, non-fatal offences. There's a lot that come between that. So assault, threats, sexual offences, there's also a couple that come between that, but like 4 main sort of topics, which is nice. There's not too much in that, and your exam question can only be on one of those 4, or there'll be multiple exam questions, but yeah, you kind of only have 4 main ones to worry about, which is good. And your assessment, which I was just talking about, is on topic 4. So this one here, which we'll be doing in 3 weeks' time. So yeah, that's something to keep in mind. So definitely when you go through the content of that, just know that your assessment is on it, and you'll be most likely, yeah, answering a problem question on that. Um, so yeah, everyone's taken a screenshot of that. That's good. So yeah, sorry, this was what I was going through with the assessments. Um, and yeah, just kind of have spoken about those. But yeah, the mid-semester is the kind of important one for now, but it's in a month's time, so not to worry too much now. Okay, cool. So I guess we will get started with the actual content. If anyone has, yeah, any questions throughout, please jump in or text the chat. I don't know how to check the chat now, but it will, yeah. Okay, it's here. I think that would have been, yep, sorry, someone's saying that they can't see the slides. Okay, cool. So everyone can see the slides now. That's all good. All right. So all right, we will just do, yeah, very introductory stuff, but it is important to obviously understand. And yeah, as I said, the multiple choice quizzes can kind of test you on any of this stuff. So it actually is quite important. So I, yeah, we'll be going through it. Jump in if you have any questions. So what is a crime? So a crime can be an act, so something someone does, or an omission, which means something someone doesn't do, that contravenes the law. So that goes against the law. And it can be followed by prosecution in criminal proceedings. Consequences obviously include conviction and punishment. So, can range from fines to going to jail, imprisonment. It is prosecuted by the state, so by the courts. And it's sort of a modern form of community condemnation. So if someone does something wrong, the community is going to condemn their behavior through punishment and yeah, through as I said, imprisonment or fines. So um, I'm sure you guys have, seen shows about this. There's so many movies on criminal law and all of that. So I'm sure sort of how it works, the prosecution and the defense, and they go back and forth and sort of try and represent their clients. So the victim and then the person who's committed the crime. And then yeah, there's a punishment that kind of arises out of that proceeding. So why do we criminalize behavior? So why are there crimes in society? So it's kind of three main things. And the most important one is obviously prevention of harm. So to prevent individuals from committing crimes, from hurting others. Um, Also vindication of morals. So a crime is also sort of morality issue, not to go into, philosophy, but obviously it's about doing immoral or morally repugnant behavior. And so we want to vindicate that and yeah, sort of condemn that. And then also expression of public concern, obviously. So kind of protecting the public through that. So punishment. So, as I explained, so crimes, then most likely the result of a crime will be punishment, unless obviously the individual's found not guilty. So it's pain or unpleasant consequence for an offence against legal rules administered by an authority constituted by a legal system. So, by the way, these definitions are the ones that I took note of from the textbook last year and from my workshop. So feel free to like refer to them if you need definitions for any of these. As I said, it could come up in the multiple choice quizzes, like what is punishment? So it's good to have the right wording as well, because we all know what punishment is, but the actual legal wording is important. And then there's some theories of punishment. So totalitarian theories are sort of forward-looking, so they kind of justify punishment. So they justify things like imprisonment, sending people to prison to jail, because of future benefits. So they're sort of saying, when we're putting someone in jail, there's a future benefit that they're not going to reoffend. And although there is drawbacks, because obviously it's been found that imprisonment isn't the most effective, in some cases, they're saying that kind of outweighs the future benefit. And then there's retributive theories, which kind of look at punishment as a response to wrongdoing. You don't have to worry too much about these, but it's just kind of the textbook does mention them, and it is, I think, quite interesting as well. Okay, so why do we punish? This is quite important. I think we got a couple of questions on this, on our quizzes, and yeah, it's just always important as well to, the whole point of criminal law is to, um, figure out if someone's guilty or not guilty, and then follow through the procedure of that. And so we want to know why we're doing this. So yes, four main reasons. The first one is deterrence. So with deterrence, and this is something to note for sure, because a lot of people, I think, just look at the deterrence in the grander scheme of things, but there's two subcategories. So the first one is specific deterrence. So here we're talking about deterring particular offenders from committing future offences. However, it is really interesting to note that research into specific deterrence shows that imprisonment has, at best, no effect on the rate of reoffending and often results in greater rate of recidivism. So that recidivism just means reoffending. It's just another way to say that. So yeah, there's been a lot of studies that kind of show that imprisonment isn't the most effective form of punishment. A lot of people, think rehabilitation, for example, is a better way. And yeah, so that's just something interesting. And then general deterrence is sort of more for the broader community, sort of educative deterrence. So when we're saying deterrence, we're trying to deter someone from committing that behavior. So specific one is that individual. So we want to, deter them from committing that again. So we would send them to jail, for example. Whereas general deterrence is sort of more showing the greater community what can happen when you commit a wrongdoing. So it's sort of the same concept, but one is more for the individual and one is for the broader community. So people understand that they shouldn't commit crimes because they can see what the punishments for those are. Um, the second one is obviously this is pretty straightforward, but protecting the community from the offender. So, if we have someone going around killing people, we obviously want to, kind of put not make them do that again. So the way we do that is through incapacitation. So that just means that the offender is treated like a danger that sort of must be contained. Um, and where an offender's punishment is intended to incapacitate them from committing further offences. So that would be through imprisonment, because if you are imprisoned, you are incapacitated, which means you cannot commit further offences. The punishment is more for what they might do in the future, not what they have done. Um, okay, so the third one is rehabilitation and reform. So as I said, it's really interesting as well when you guys are learning the law, as you are in first year, to kind of start thinking about like policy changes and the debates that are going on around the law. There's always people debating about the law, what should take place, what shouldn't, and there's a big debate about deterrence and rehabilitation. Which one's better? So weighing up the two. So rehabilitation is sort of dealing with the offender's outward behavior. So for example, if someone has an alcohol problem and maybe they have committed they drink driving or dangerous driving because of alcohol abuse, then they might be rehabilitated sort of through that. And that's kind of targeting their actual behavior instead of, you know, just giving them a fine or something like that. Reform is more about personal attitudes and values. So these go hand in hand, but yeah, kind of getting it's a little bit more thinking more deeply about the wrongdoing that someone's committed. And then retribution is vengeance. So yeah, so those are those three that are also very important. And then the fourth one is denunciation and censure. So basically just denouncing the misconduct to the public. That sort of relates back to general deterrence. So that's why a lot of crimes go on the news because people need to hear about them and the offender needs to be denounced to the greater public because that is also a way to punish someone. And then censure is the crime was wrong, this is addressed to the offender, and to accept that means that you sort of are accepting that what you did is wrong. So yeah, those are the four main reasons why we punish, and as I said, these are quite important, so definitely have a note of those. All right, so let's jump into the framework of criminal law. So the most important thing here, and I'm sure watching movies, you guys probably have heard this before, the innocent until proven guilty. So the standard of proof must be beyond reasonable doubt, and I'll just quickly explain this on the next slide. So this is called the golden thread. And it basically sets the standards of burden of proof in criminal cases. What I mean by that is when the prosecution, so they're defending the victim and the defense who's defending the perpetrator or whoever committed the crime, when they are sort of arguing their case, there's a burden of proof that they each must have, and the innocent until proven guilty basically means that the burden of proof is beyond reasonable doubt. So it's a high burden of proof. Someone doesn't just start off, being guilty and then they have to be proved innocent. They start off being, everyone, starts off kind of being considered innocent and then they have to be proved guilty. And that just kind of ensures, fair trial. So I'll just read this quickly. So it originates from this British case, which is against Wilmington. You don't need to know this case, but it's just where this principle comes from. And yeah, it basically states that in criminal cases, the burden of proving guilty lies on the prosecution. So it lies on those representing the victim and must be proved beyond reasonable doubt. So this principle ensures that defendants are presumed innocent until proven guilty, and it emphasizes the importance of procedural safeguards, so such as the right to a fair trial, legal representation, and the exclusion of evidence obtained unlawfully. So the golden thread's an important one, and yes, they can
Right.
definitely, yeah. A question. Sorry, I don't know if someone's.
Saving everyone. Oh my God. LSS.
Yeah. Okay, so the microphone's gone off. I don't have. If anyone, has put questions on the chat. I'm trying to see if. All right, cool. No, there's no questions on the chat. So yeah, just that last bit in bold there is quite important. Just if they ask a question on what is the golden thread, usually they wouldn't because it's pretty straightforward, innocent until proven guilty. But the reasons behind it are quite important. So definitely make a note of those. I know a lot of people got tripped up on that during the quizzes. Um, okay, cool. So two types of crimes. This is really, really important and it will follow on throughout all of your law subjects. But I mean, pretty straightforward. You guys probably already know this, but just there's a difference between common law crimes and crimes in codified legislation. So throughout criminal law, we will be looking at these two types of crimes. Common law crimes are crimes that arise from the common law, and you guys would have learnt this in Foundations of Law. So crimes that arise from cases, just cases. There's no legislation on them. So with murder and manslaughter, which we'll be covering in topic 6 and 7, they are common law crimes. So we'll be learning those by looking at cases. There's no legislation on those. Whereas other crimes such as sexual offences or non-fatal offences, which is topic 4, which is what your assignment's on, those are codified legislation. So we'll be looking at the Crimes Act. That's the main bit of legislation that we'll do in criminal law. There's also the Criminal Procedure Act from 2009 that we'll be looking at briefly, more for these sort of topics. But those are really, really important to remember that when you're doing murder, for example, there's no legislation on it. You're just looking at past cases and taking principles from those. Okay, cool. So offenses. So they're split up into 3 different ones. This is really, really important. I have tried to, sort of make a summary on those for you guys. So, firstly, indictable offences. So, these are more serious crimes, okay? So, as I said, they might be statutory, so coming from codified legislation, as I just explained, so from the Crimes Act, or residual common law offences, so like murder and manslaughter. Um, they are tried by judge and jury in the county or Supreme Courts after a committal hearing in magistrates court. So they're kind of tried in higher courts. Obviously, if a crime is a grave crime and a more serious crime, then they will be heard in a higher court. And there's more serious penalties, obviously, so higher fines and longer prison terms. And then we have summary offences. Okay, so these are all statutory offences, most of them. So a lot of them are sort of like non-fatal offences. So yeah, most of them are found in the Summary Offences Act, which we don't actually really look at in criminal law. one, but just to keep in mind, so it can be drunk and disorderly, minor traffic offences, minor property damage, um, intimate images without consent, stuff like that. And they're dealt with in the magistrate's court, and they have lower penalties. So they have fines. You can have up to 2 years of imprisonment for one offence, and then max of 5 years for multiple offences. So that's something to keep in mind as well. Um, there's guidelines for, and we'll look at this when we do sentencing next week, but there's guidelines for different crimes, and so judges know how much they can imprison someone, or what the highest fine they can give is. So, however, so those are those two different ones. So indictable is more serious ones, summary is sort of less serious crimes. But indictable offences can be tried summarily. So what this means is the more serious crimes, some of them can be heard in the magistrate's court and can kind of be given lower penalties. So you would see why someone, a prosecutor, someone who's committed a crime would want, if it was an indictable crime, they would want it to be trialed summarily because there's lower penalties that are handed out. So this obviously is only for less serious indictable offences. Don't worry about this bit because we will look at it next week, but um, punishable level 5 or 6 penalty scale and imprisonment of less than 10 years. So this is in Schedule 2 of the Criminal Procedure Act. And as I said, they're tried by the magistrate. And yeah, so this could be something like theft, minor fraud, minor drug offences, and some assaults. So that's just something to keep in mind that, yeah, not all indictable offences are tried indictably. They can be tried summarily. Okay, cool. So yeah, feel free to take any screenshots or anything, obviously, as this is a nice summary of all of them. Okay, so there's a bit of ambiguity on who can commit crimes. Obviously, I'm sure most of you would know about infancy, so children under 10 can be convicted of a crime. However, if a child is between the age of 10 and 14, they can only be convicted, sorry, that's a typo, be convicted if they know their conduct is wrong. So this is the Latin word for this is doli in capax, because a lot of the time, obviously, children lack this sufficient intellectual and moral development to know that what they've done is wrong. And when we look at the elements of a crime, which will be in a couple of weeks, one of the elements is mens rea. So that means sort of your mental kind of intention, your mental, yeah, it's kind of if you know what you've done is wrong, or you have to have some sort of mental element to your crime. So if you don't know that you've done something wrong, it is really hard to obviously persecute and punish someone. So that's why children under 10 can't be convicted. So obviously in this also family level, educational level, social environment, presumption of sanity and fitness to lead are also factors that are considered. And children's courts have exclusive jurisdiction between 10 and 18. So they are sort of, there's a different court for them and they are dealt with in a different court, apart from homicide. So yeah, just something interesting to note, as I said, always interesting to follow the law and see how it's changing and see where the arguments and debates around the law are. There is a strong debate whether to raise the criminal age to 14. So a lot of people think that 10 is too young. They sort of, yeah, think that between 10 and 14, kids are still too young to understand their wrongdoings. And so, yeah, that's kind of a debate that's going on right now. And then immunities is another one. So aliens who commit crimes within the jurisdiction can be arrested and tried like citizens. So yeah, extradition, which is basically sending one to another country for trial. So if an alien's in Australia and I'm not sure, maybe from Italy or something, sending them back to their country for trial is possible if they flee before trial. But this is all to do with treaties and with countries of residence and immunities from prosecution and extradition once extended to foreign sovereigns and heads of state and diplomats. But obviously that's not the case anymore. Everyone is held accountable. But yeah, you don't need to worry too much about that, but it's just something to know that could come up. Okay, so criminal procedure. So this is obviously from the Criminal Procedure Act. And yeah, there's sort of four main outlines of this, and this is will be highly dealt with in criminal law too. So you guys will probably do that if you're doing a double degree in your fourth year. So it's a while away, but yeah, it is. You do need to know the foundations of this now. So obviously, a criminal procedure starts with a police investigation. Okay, so this isn't part of the legal procedure, but it is still very, very important to note that. As you see in films, the police will go to the crime scene, commence investigating, and then the criminal procedure kicks off from that because the police has been able to gather evidence and do all of that sort of preliminary stuff. And then we have the arrest, charge, prosecution, and infringement notices. So the charge, someone being charged with a crime, is what initiates the criminal process, or being charged with an alleged crime. Obviously, it's all alleged until it's been proven. So that's the first process. Then we have arraignment. So, um, yeah, if someone pleads guilty or not guilty, so they'll be asked in court, do you plead guilty? Which obviously means have you committed the crime? Do you plead not guilty? Obviously, a lot of people don't plead guilty because, either they lie or that's what their lawyers told them. Or some people obviously aren't guilty and they've been charged wrongly. And then if pleas not is guilty, there's no trial. So if someone says, yes, I committed this crime, there's obviously no point having a trial and arguing both sides, and they will be accused straight away. And then there's also no case submission. So the accused could argue that there's not enough evidence to sort of support a verdict. And that's obviously to the discretion of the judge to decide if there is enough evidence. So if you guys want to take a screenshot of this as well, this is sort of the stages that I was just talking about in a little bit more depth. So the investigation stage, the committal stage, trial stage, plea stage, sentencing, and appeal stage. And then, yeah, sort of they each kind of branch off. So yeah, this is important to know. And yeah, quite interesting actually as well. So appeals, this is another important thing to note. So if there's been a legal impropriety by a lower court, the accused can, or the accused or the prosecution, they can appeal on question of law. So this is really important. So with appeals, um, the prosecution can't appeal against an acquittal. So if the prosecution believes a mistake of law was made in the course of trial that led to an acquittal, it can be allowed to appeal because it's a question of law. If the prosecution then wins this appeal, it does not affect the acquittal of the accused, but sort of stands as a precedent for future cases. But appeals cannot be on question of fact. So it is only if there has been a sort of error in the application of the law or in the law itself. It has nothing to do with facts. It cannot have anything to do with facts. So always important, and that's not just in criminal law. That's in all law subjects and all appeals. Okay, cool. And then this is the Charter of Human Rights and Responsibilities Act. So um, you won't go too much into this in criminal law. It's more you'll look at it in public law and statutory interpretation, which you guys will be doing next semester. But it's just something to keep in mind that there's some sections in there about like Section 24 about having a fair hearing. Section 25 looks at rights in criminal proceedings. Section 26 looks at rights not to be tried or punished more than once, humane treatment when deprived of liberty, and right to liberty and security for a person. So definitely good to keep in mind. I don't think you definitely won't be asked these in depth, but yeah, it could come up. What section looks at a fair hearing. So just know the sections and just kind of know briefly what they will cover. Okay, so this is the last sort of bit of content we will be going through. Before I do that, does anyone have any questions or everyone's kind of following along? No questions? That's good. So yes, R against Brown. So this is probably the main case that you guys have looked at this week and will probably be looking at in the weeks kind of leading up to the elements. And I think it is a really important case. So I did just want to go through it. In the coming weeks, I probably won't go through cases in depth. I might if I think it's a complicated case and if I think it's an important one. But a lot of cases, it's just reading the facts and taking out the principle from it. So I'll more be talking about the principles from cases as that's what you'll be needing to apply. At the end of the day, for the exam, you don't need to know the facts of every single case, as long as you know the principle and sort of how you can apply it to your problem question. But with R against Brown, it's more about the principle. So basically, it involved a group of sadomasochistic individuals who, over the course of 10 years, participated in acts of violence against each other. So it was genital torture. The victims were consensual and they received no permanent injury, and this occurred in private premises. So I think it was at one of their houses. So the question here is, well, yes, they committed harm against each other, genital torture to be exact, but they were consensual. They consented to being harmed, and they received no permanent injury, and it was also in private premises. So it's the question of, should the law intervene in this case? Should the law intervene in prohibit individuals from consenting to their own harm? And it's a very interesting question about consent and that. So it's a UK decision. It was a case, from the United Kingdom, but there's sort of two really important things to take away from it. So the first one is from Lord Templeman, which was the majority. So this is what was held, and it's sort of been named the libertarian doctrine. So consent, he's sort of saying that consent should not remove liability for sadomasochistic homosexual encounters. So consent doesn't allow a crime to be lawful. You can compromise your civil rights, but not those of the public interest. So sadomasochistic participants cannot foretell the degree of bodily harm which results from these encounters, exploitation and corruption of these vulnerable, young, weak, in body of mind individuals. So his kind of famous quote as well from this case was that society is entitled and bound to protect itself against a cult of violence. Pleasure derived from the infliction of pain is an evil thing. Cruelty is uncivilized. I would answer the certified question in the negative and dismiss the appeals of the appellant against conviction. So the appellants, appealed this case, and the appeal was dismissed. So he's sort of saying that even though someone may consent to being harmed, that shouldn't make the act lawful. And it's about sort of protecting society and protecting individuals who are sort of, this quote here, vulnerable, young, and weak. So that's sort of, he's more talking about protecting the public and protecting individuals as well against themselves. And there's just a little thing that, for example, a person who assists another to commit suicide could be guilty of murder. So obviously no one died in this case, but individuals were helping each other inflict harm. And so that's sort of where this also stems from. However, there was a dissenting opinion from Lord Mustill, and he was sort of saying that it's not a question of morality. So it's not, the law shouldn't be considering if it's morally right or morally wrong, but it's whether it's probably charged under the Offences Against the Person Act of 1861. So this is an English act, so obviously don't worry about this, but that's what they were applying it to. So he was balancing the risk as well against the interest of individual freedom. So, individuals are free to do what they want, and he was saying they should be free to consent to pain, and no one died as well. So he was saying you can't condemn if these consequences don't ensue, and consensual acts are not offences against the existing law of violence. So very, very important case, as you guys can see, because it's talking about two very separate kind of two very separate interpretations of consent. And obviously this is what was held, so this is what you should know from this case and the decision, but definitely keep in mind what else was said, not about morality, but about if they can be charged under a legislation. So yes, this can definitely come up in those quizzes, and definitely an important case. And it comes up as well throughout your law degree. So yeah. All right, so that's all the content done. Yeah, the first week is kind of obviously less content because it is more introductory stuff. But I have prepared some practice questions for you guys. In the coming weeks, when we start looking at elements of a crime and we start actually doing the crimes themselves, we will probably spend more like half of these tutorials looking at practice questions because at the end of the day, I think practice questions and people who have gotten HDs in subjects will tell you that practice questions are the most important thing. There's no point knowing all of the content really well, but then not being able to apply it. So I want to spend at least especially in the longer kind of like topic 4, because that's what your assignment will be on. I want to spend at least half an hour doing a practice question and give you guys the chance to, practice applying the law to it. But for now, for topic 1, 2, and 3, we'll probably be doing more multiple choice questions because that's what your assignment for those will be. Topic 3, actually, we will do a problem question as well. But yeah, I just wanted to quickly, before I put up the multiple choice questions, there's only about 8 of them, so not too much. But I wanted to quickly talk about multiple choice tests in law school. So I'm not sure if you guys have done your Foundations of Law test yet. I feel like it's around week 4, week 5, so it might be coming up. And as I said, speaking to first years, I know they're a little bit stressed about that. So that's a big, big multiple choice test. And you guys, if you haven't done it yet, will be surprised because it is quite difficult. I know this year it is open book. Last year it wasn't. So we had to memorize everything for the first 5 weeks of content, which was not fun. But because it's open book and because a lot of law school is open book, they do make the multiple choice tests quite difficult because you have all your materials. And so yeah, it is just, and it's like VC as well. I mean, I think VC subjects now are getting harder in the multiple choice questions, but just keep in mind that multiple choice tests, don't look at it and be like, oh, it's going to be fine. It's just a 10%, 10 question multiple choice test, because they are difficult, and they are trying to challenge you guys. So I think with the Foundations of Law one last year, like our average was very low. It was like 60% in the class. So that's okay. Criminal law is a little bit higher, and you should be aiming to get a little bit higher in that because yeah, it is 10 questions and um, it is doable. I think it's definitely doable if you revise the content. But yeah, just something to keep in mind. So don't be discouraged as well if you find the first one super, super difficult. I know I definitely did. Okay, so I will put these questions up. So this is the first slide, and then there's like 4 more on the next one. Um, yes. So I will maybe leave this up for like 3 minutes. So yeah, you guys get 1 minute per question in the actual one. So maybe we'll do 4 minutes. I'll leave it up there, and then I'll move on to the next one, and then we'll correct them together. Right, I'll give you guys 1 more minute. Yeah, and then we'll move on to the next ones. Okay, cool. Is everyone happy for me to move on to the next slide, or does you can just let me know in the chat as well if you need more time with those. No, it's all good. Okay. Oh, that's already moved on to the next one. Okay, cool. Yeah, there's just three on that one. So I'll give you guys 3 more minutes. One more minute and then we'll go through the answers. Right, cool. Yes, let me know if people are still doing them, but I think everyone seems to be done. So let's just go back to the first ones. So I'll just go through the answers and give a brief explanation. These shouldn't be too difficult, but yeah, sometimes it's just like the wording of them that kind of trips people up. So the first one. So, following statement best reflects the principle of innocent until proven guilty. Um, the answer for that one is A. So, prosecution has the burden of proving guilt beyond reasonable doubt. So, that's the golden thread. Um, so, yeah, obviously, yeah, the other ones look right, but just always remember it's the prosecution with innocent until proven guilty. So, prosecutions representing the victim, they're the ones that are trying to prove that the person who's committed the crime, so the accused, is guilty. So, they're the ones that have to prove that. And so, they have the burden of proof. Um, so, yeah, answer for number one is A. Um, I can also maybe put these answers, oops, sorry, in the chat as well. I'll put them in the chat if people like need a reminder, but yeah, it's better if we go through them together. So second one, what's the key difference between rehabilitation and reform in the context of punishment? So the answer for this one is also A. So yeah, rehabilitation, as I said, is treating the offender's actual behavior. So the example I used was, someone who's been abusing alcohol. The rehabilitation would be, kind of targeting the alcohol abuse, and then reform might be thinking about more their attitudes and values towards that. Um, yeah, so the other ones are just obviously the other way around. So that's why they're wrong. Number three, so main criticism, use of imprisonment for specific deterrence. So the answer for this one is B. So it often has no effect on reoffending and may increase recidivism. So that's reoffending, that word there. Um, Obviously, imprisonment, you can argue that D is correct as well. It violates human rights. it could also lead to overcrowded prisons. Um, but yes, the most important one, and that's why also the questions really trip people up in the multiple choice quizzes because there's only one specific right answer, but the other ones do look right. So just make sure if it says main criticism, the main criticism is this one here. So yeah, just kind of be careful with that. Which of the following offences are categorized as indictable offences under Victorian law? So the answer for this one is um, sexual offences. So C. So indictable offences, if you guys remember, are the more serious offences. Obviously, all those offences are serious, but the most serious out of them, yeah, is sexual offences, and that's an indictable one. Okay, so yes, so the answers are for this page are B, and C. All right. And then for this one, so what's the legal standard of proving guilt in criminal cases? Um, as discussed in the English case. So the answer for this one is C, beyond a reasonable doubt. Make sure you know that. Just really, really important. Beyond reasonable doubt. So, yep. Nice and straightforward. Six, which of the following best represents the concept of paternalism in criminal law theory? So this was kind of to do with those theories that I spoke about before. As I said, they're not super important, but this could come up. So the answer for this one is A. So the state should limit personal freedoms to protect individuals from harm. So this is the concept that also came out of the English case R against Brown. So the one we were just talking about with the sadomasochistic individuals. Yeah, the concept of paternalism was obviously applied there because the judges said, well, we should limit the personal freedom, so the freedom to choose to consent to harm to protect individuals from harm. So that's sort of from that case. And then the last one, what's the significance of the golden thread in criminal law? As I said, this could definitely come up. The way they ask about the criminal thread, the golden thread, sorry, is like this. They'll never ask you what it is. But yeah, the answer for that one is B. So it emphasizes the importance of a fair trial for the accused. Because if you're innocent until proven guilty, it means you're sort of starting off at a fair advantage. Everyone is assumed to be innocent. Um, yeah, so answers for the second page, as I said, were C, A, and B. Okay, cool. So that is everything. Just two quick things before I let all of you guys go. As I said, feel free to like stay back if you have any specific questions or anything. I might just stop sharing my screen. Yeah, if you want to stay back and ask me any questions, I'm super happy to answer them. But also, if you have any questions and want to email me, my email is on the LSS page. And yeah, I will be responding to all of your guys' questions on there. Also on the LSS page, and I posted this on the Facebook group as well, how to access, but I have uploaded sketch notes. And problem questions. So the problem questions we'll be doing in tutorials. They're all on the problem question worksheet. So I recommend before the tutorials, you guys kind of having a read of them so that we can jump straight into them and we're not spending time kind of discussing the facts. So then you guys get a better chance of obviously asking me questions and applying the law and I can run you through the structure of your answers. So yes, definitely hop on the LSS website. There's instructions how to do that on the Facebook and download the sketch notes because they are the notes that I had for for criminal law and that got me a HD that I wrote up myself and then the problem questions so that you can start having a look at those and if you want to go back and if you maybe didn't get some of these multiple choice ones right maybe go back and redo it again or something and yeah, contact me through email if you have any questions or you can also send me a message on Messenger, whatever you guys prefer. But yeah, that is everything for the first week. I hope you guys enjoy second week's content as well. And I will see you next Friday and we'll be talking about sentencing. Yeah. All right. Bye, guys. And yeah, feel free to stay back if anyone has any questions.
Hey, I just had a quick question.
Yes, of course.
I think I just missed like the last bit for the last multiple choice question.
Oh, yeah.
Why was it B? Like why was the answer B?
Yes. So let me just get it up. So it was significance of the golden thread, yeah? Yeah. So with the golden thread, do you want me to share my slide again that kind of
I've
explains?
got the question up on the side, so that's fine. But
Okay. I'll just share like the slide again, but
oh
I'll
yeah,
explain it quickly because it is kind of a confusing concept, so I completely get it. So basically the golden thread, can you see that by the way? Yeah.
yeah,
Yeah, so the golden thread basically explains that yeah, the innocent is sorry, the accused is innocent until proven guilty. And the main reason why that is so the accused has a right to fair trial. So the answer, so let's look at the other answers. So it does provide guidelines for sentencing offenders, obviously, but the main significance of it is a fair trial because if someone is starts off as innocent and then has to be proven guilty, there's obviously a higher threshold for them and for evidence to kind of prove that they've sorry, committed the crime. Whereas
yeah.
if it was the other way around, right? So if it was guilty until proven innocent, you're already starting off at a sort of disadvantage, if that makes sense. You're already starting
Hmm.
off to be considered someone who's committed a crime. So yeah, the main reason for that, and look, A could be right here as well because it does provide a guideline. Um, but yeah, B, it just ensures a fair trial. So that's the main thing you need to remember from this because so many people got this wrong in the multiple choice.
Okay.
Just yeah, remember fair trial and fair trial. All of this is like a kind of subcategory of the fair trial. So that's yeah. The
Yeah.
B and D would be wrong with that one because that's kind of not what it's targeting. Yeah, does that make sense?
Yeah, that makes sense. No,
Okay,
I'd put
cool.
A, so I was like a bit confused, but that makes sense.
Yeah,
That's like
no, A is correct. It's
stereotypical. Yeah.
just which one's more correct. That's what I was saying. It can be really
Yeah.
confusing sometimes. But yes,
Okay.
no, good job. All right. Well, is yeah, enjoy the
Yeah.
rest of your day.
All
Bye
right.
bye.
Thank you.
All right, bye. Good.